The matrimonial home has the most significant legal status in all of Ontario family law. When it comes to the matrimonial home, everything we think we know about the law goes out the window. So it's very important for separating spouses to understand how this affects them. The first thing to understand is that Ontario treats married and common law couples differently. If spouses are not married, there is no such thing as a matrimonial home. The formal legal definition is found in Ontario's Family Law Act, which has led to lots and lots of litigation as to how to interpret this. For all intents and purposes, it's the home in which the spouses ordinarily lived at the time of separation. It's even possible for families to have more than one matrimonial home, which is usually a cottage or a vacation home, or even a condo at a ski hill, for example. Now to the most important question, why does this matter? We can break down the implications of this into two distinct categories. The first being the right of possession, and the second being the financial consequences, which could be extremely drastic when working through the equalization of net family properties. But in this video, we're only talking about the most important right, which is that of possession. Now let's see how this works in practice. This is James, and this is Alex. Their marriage has broken down and they've decided to separate. This is James's house. He bought it with his own money, he carries the mortgage himself, and his name is the only one on title. Now, ownership and possession are two separate things. Our law says that each spouse has a right to possession of the home, regardless of who owns it. This means that James cannot force Alex to leave. He can't change the locks, he can't sell the home, he can't refinance or borrow against it. All of these things require the consent of both spouses because it is a matrimonial home. In some situations, spouses can ask the court to make an order for what is called exclusive possession of the matrimonial home. Now, keeping in mind that ownership and possession are two separate things, it's possible for Alex to force James out of his own house. Now, let's assume that Alex and James were never married, but they still live together as a common law couple. With very narrow exceptions, our law says that James can do what he wants with his property. He can force Alex to leave, he could change the locks, he could list the house for sale, and so on. If Alex refused to leave, he could even be liable for trespassing. As always, it's important to speak to a knowledgeable family lawyer who can give you advice on the specifics of your case.